And welcome, ladies and gentlemen. I call to order the December 14, 2016 public hearing today to consider a remand from the Oregon Land Use Board of Appeals related to a previously approved comprehensive plan change and zone change. Before we begin, I'd like you to rise and join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Today will be our chance to deliberate on the application by Bruce Goldson on behalf of House Construction for property commonly known as 20646 and 20666 South Highway 213. This particular request is on remand from the Oregon Land Use Board of Appeals and consists of two separate requests. One, a post-acknowledgement plan amendment of the Clackamas County Comprehensive Plan to redesignate a portion of the subject property from rural to rural industrial, ZO 490-13-CP. And number two, a corresponding zone change from RRFF 5, Rural Residential Farm Forest 5 acre, to RI, which is rural industrial, ZO 491-13-ZAP. Assisting us in the hearing today is our board clerk, Mary Rathke, senior planner, Martha Fritzie, and assistant county counsel, Nate Boderman. There will be no public testimony received at the hearing today. All materials submitted during the open record period described at the last hearing have been included in the record for consideration in this matter. Before we proceed further, we'll have the reading of a legal statement by Nate Boderman, our assistant county counsel. Nate?
Good morning, Commissioners. At this time, I'll ask the Board of Commissioners to disclose any ex parte contacts, bias, conflict of interest, or other circumstance which may prevent the individual from making a fair and informed decision. Please indicate the nature and extent of the ex parte contact, bias, conflict of interest, or other circumstance, and indicate whether you intend to participate in or abstain from the decision this morning.
No contact with either party for me.
I have no conflict. No comment.
Okay. Hearing none, does anybody in attendance today wish to challenge the impartiality of any commissioner here? Seeing none. All right.
So I've asked that they do at least a brief, for the public that's watching today, they don't know how we got here today, and because it's pretty short information, but I've asked staff to do a brief presentation about where we're at and why we got here. And that would be you, Martha, I got a feeling.
Yes, it is. Good morning. Martha Fritzie, Senior Planner with the Planning and Zoning Division. And I am going to be very brief, hopefully. On October 26th of this year, we held a public hearing to review the proposed response for the LUBA remand, the Land Use Board of Appeals remand, related to the proposed comprehensive plan and zone change on the property you described, also known as commonly as the house construction property. And at that hearing, we discussed the 7 assignments of error that LUBA remanded, and I'm going to very briefly go through them just to jog everyone's memory. The first assignment of error related to LUBA finding that the county had not established that redesignating the property did not require a new exception to statewide planning goals. That related to the way that the administrative rules were written at the time. They have subsequently changed, and the need for that has been determined to have been cleared up by the change in the administrative rules. The second assignment of error had to do with the decision to relocate the driveway. If you recall, it's relocating to the northern portion of the property, and the question whether or not the historical commitment to the rural industrial use had been adequately explained. The third assignment of error had to do with the questions about findings related to the rural character of the particular use that's proposed on the property, which is a construction and maintenance company, and whether or not that is considered non-labor intensive because a rural industrial zone requires not labor intensive uses. The seventh assignment of error had to do with the timing of when the proposed driveway location had showed up for, and let me back up. The assignment of error has to do with the fact that the exact location of the driveway as proposed showed up in the ordinance. And while it had been discussed in the hearings, that was the first time it had actually been seen, and there's concern that there hadn't been adequate time allowed, which has now, because the drawing has been out there through this whole process. The eighth assignment of error also is related to the administrative rules that have changed and is no longer necessary to address. The ninth assignment of error had to do with the way the traffic impact analysis had been completed, and you'll recall a new traffic impact analysis was generated that followed the direction from LUBA that it needed to. And finally, the 10th assignment of error that was discussed also related to the movement of the driveway to the north and questions about whether the findings addressed potential safety concerns with that driveway move. So that's what was discussed at the hearing. There was a lot of testimony, and as Nate mentioned, the public hearing was closed and continued to this date for deliberation and decision.
Nate, do you have anything to add?
I don't. I guess I'll just add that based on what the applicant submitted so far, it remains staff's recommendation that the application be approved, that everything, or that the information is sufficient to address the criteria on remand from LUBA. What you have before you this morning is three options, which you typically have at any land use hearing, is to approve the application, to approve with modifications, or to deny. So that's the decision before you this morning.
Commissioners, do you have any questions of staff? Yes, Commissioner Savas.
I do. Nate, should, of any of these three options, the board take action on today, which obviously will do one of the three, what are their options should someone not like the outcome, one side or another? I mean, is this appealable? I mean, what could continue conceivably?
Yeah, this is a land use decision, so the Land Use Board of Appeals would have jurisdiction over that, which means once the decision becomes final, and final decision being the adoption of the final order, there's a 21-day appeal period then to LUBA, and then we go through briefing, and typically you get a decision 4 to 5 months out.
Okay, thank you.
All right, other questions, Commissioners? Otherwise, remember, yeah, we've accepted all the testimony we will, and actually we're ready for a motion.
I can do that. I move to approve Z0490-13-CP and Z0491-13-ZAP, subject to the revised conditions of approval as recommended by staff.
Is there a second?
I'll second that.
Okay, motion by Commissioner Smith, second by Commissioner Savas. Discussion.
I'm not sure how this is going to turn out today, but I will say that I've been struggling with past decisions that this board has made in small changes like this. And I've seen the board take action, and also seen even the legislature inject themselves into some of these things, which resulted in a change on some what we would call spot zoning. I know that spot zoning was something that was thrown out at the last meeting as a concern that we shouldn't be doing that, but we do that. As a matter of fact, we not only do it, but it's being recommended that we do it in other areas around the county. So I was struggling at the last meeting figuring out, wait a minute, I mean, you know, are we being consistent or not? So I understand the concerns of both sides. I truly do. So my comment on this whole thing is that I see that there's been safety issues that have been raised about the ingress egress. I see that approving that would result in a positive change in that the applicant, I guess in this case, would be making those improvements and increasing safety there. So I think I see that as an upside. But again, I also understand that the concern about that change, but If this was embedded deeply into a neighborhood off the main highway, I would think about it differently, but just knowing what's down the road, both north and south of the highway, there are like uses in the sense of they are non-residential type uses in those areas. So that's all I have for comment.
All right. Anybody else wish to comment on the motion? All right. Mary?
Commissioner Bernard,
No.
Commissioner Smith,
Aye.
Commissioner Schrader,
No.
Commissioner Savas,
Aye.
Chair Ludlow.
No. Now, we're ready for another motion if you see
Aye.
fit, but I just want to comment on why I said no. You know, after driving this property, around this property on the highway, and certainly driving 213 a ton of times, I'm really doubtful of its what light industrial means. And I know I've certainly talked to staff about light industrial. What is light? Well, certainly, you know, coming from Wilsonville, we always said we'll never have heavy industrial, we'll always have light industrial, and we did that. And we held some people's nose to the grindstone in regards to that and trying to achieve that. You know, the trucks themselves, and we heard testimony initially when we heard this a year or so ago, the trucks themselves are a real pain. You know, diesels and working on diesels and heavy equipment is noisy around that neighborhood, and it is still a residential neighborhood. We've got to remember when rural industrial is inserted into these neighborhoods, usually the compatibility is keenly looked at for a good reason. Is that light industrial compatible with the neighborhood, or does it fit like kind, or is it really an intrusion into? You know, I've had some concerns before also about the rural character being lost, the historical commitment to usage. You know, we heard it was a shop, you know, and a little 3-car garage thing, but we also heard some neighbors that were around there for a long, long time who said it just wasn't so. And again, I'm looking at an enhanced usage of that property, which right now looks like industrial to me. I mean, you can call it light, but I don't think it is. I think it's pretty heavy. So, Jim, you wanted to make a motion?
Yeah, I move to deny ZO, is that an O?
Yeah.
490-13-CP and ZO 491-13-ZAP.
Is there a second?
I'll second that.
Motion by Commissioner Bernard, seconded by Commissioner Schrader. Discussion.
Yeah, I just briefly want to say that when we had another industrial use applicant here on a land use matter that was in a different part of the county, and it was zoned industrial in one area and residential in another, and there were some issues with the particular use that was there. We seemed to have a different opinion at that time. I just want to point that out.
Well, each of these, by their very nature, are different. There ain't none of them that are the same. And so, you know, we will vote on this one, and certainly the parties as outlined have their options to go forward. Are we ready for the question? Mary?
Commissioner Smith,
No.
Commissioner Schrader,
Aye.
Commissioner Savas,
No.
Commissioner Bernard,
Aye.
Chair Ludlow.
Aye. Passes 3-2. Now, it is probably very good that we give the opportunity for our staff to draft findings, and so let me go through my options here. So now that the matter has been decided, I will direct staff to draft an ordinance reflecting today's decision and including on the agenda for the board's adoption at a future business meeting. Are we okay with that, Nate?
That'll work, yes.
That'll work, okay. So I think that our work here is done, correct? There being no further business before us this day in the land use hearing, this meeting's adjourned.